Hello everyone, welcome in. In this video, we will be discussing the medical records as evidence in the Alexee Trevizo case. As it stands, these medical records are still supposed to be sealed, though they have been leaked online by a defense witness. Them still being sealed precludes me from sharing the contents of the medical records. The medical records themselves are not the main issue when it comes to this piece of evidence. They are an extension of a lot of other things that have happened in this case that I find to be extremely legally relevant, seeing as the judge apparently did not suppress the medical records. Just to repeat that to you, the judge did not suppress the medical records in this case, meaning they are currently admissible, even before the appeal to the Supreme Court. The other side of that coin is that the judge has decided to suppress all statements made by the defendant, aka Alexee, to her healthcare providers. There is a reason why the statements have been suppressed, but the records are not, and that is what we'll be going through in this video as well. So obviously, why are we here? Well, number one, the defense really needs these statements suppressed. And number two, the state really wants these statements admissible. Though some may think the state's case is not valid without the statements, the scales tip more towards the defense needing the statements suppressed than the states needing these statements admissible to make their case, in my opinion. Why? Because the state can infer the intent to murder based on other evidence, but the statements made to hospital staff that led them to feel that they were, quote, being lied to or tricked, or that show the defendant subverted the care or attention to anything other than being pregnant, that pretty much makes it an open and closed case as far as the intent, in my opinion. If defendant was proven to be evading the truth of the matter before the alleged crime, that's even more proof of the intent. Right? So that is why I think it actually is more imperative that the defense keeps these statements out than the state have them for their case. So, like I said a minute ago, it is quite interesting that the judge decided to keep the medical records in as evidence, but suppress any statements the defendant may have made. So for the Supreme Court series, we are going through the evidence that we do have, which is why we're focusing in on these medical records. If you notice here, this is a snippet from the defense when providing the exhibits used for the motion hearing way back in August of last year. Now, this document here was filed in July of this year. If you notice, the defense states that the records were not sealed, even though that the defense had asked for that. I find that odd. Now, it does appear as though there have been requests for this case information by multiple people, extremely large YouTube channels, actual syndicates, media outlets. What would be interesting is if the record was not properly sealed, why do we not see this sealed information posted anywhere other than from a named defense witness on their platform? You will see here, this is the list of the exhibits from the document you just saw that the defense offered in the hearing last year. Exhibit A is the medical records. Like I said, the only known place that you can find the medical records posted online leads back to defense witness, 10th woman, aka Miranda. Every time. No one else has posted a copy of these medical records. So since the defense attorney has stated that the record was not properly sealed, I'm just wondering why only one known source of the sealed information has ever made its way into the public, though other people would have motive to also share that sealed information should they have obtained it. To further that point, I had launched my own investigation into the leaking of the medical records. So since the defense attorney has stated that the record was not properly sealed, I'm wondering why the only known source of the sealed information has ever made its way to the public comes from the known defense witness, 10th woman. Here is some screenshots of the documents that she does have posted, the screenshot from the defense witness list showing that she's on there, and an arrow pointing to the link tree where you can find all of these documents hosted by her. To further that point, I had launched my own investigation into the leaking of the medical records. I had found a print date on an unredacted copy that the defense witness had posted. I knew I had finally gotten somewhere with that investigation because the print date, as referenced by the little red arrow here on the screen, was extremely interesting. Now, this date and time for the specific copy of the medical records floating around in this case was April 13th, 2023. An odd date unless you put some surrounding dates in this case around it and begin to form a timeline. First and foremost, obviously, the incident takes place on January 27, 2023 at Artesia General Hospital. The autopsy does not come back until March 28, 2023 as homicide. It was always my speculation when I launched this investigation, and we stated it here on this channel multiple times, that the medical records posted online were likely the state's copy of the court-ordered medical records based off this date. this date has the proper amount of time to get a court order for the medical records after the autopsy comes back, and that it would be in accordance with New Mexico state law. And for reference, the green arrow on the screen is pointing to a message that I obtained that was sent by defense witness Miranda to a very large TikToker right after the leak, essentially, claiming that it was indeed Alexee's sister leaking this sealed information to defense witness 10th woman, aka Miranda. So you can take that for what you will, but just a side note in this investigation and in this information that you're being presented. So why does this all matter in the grand scheme of all the things happening in this case? Who cares if these medical records were leaked? Well, as you saw earlier, the defense seems to care since they have mentioned the record not being sealed and they have the leaker on their witness list. Well, there was a second leak that also happened in this case that came from the same defense witness, and that was the judge's decision on the evidence, a completely sealed document verified by the court, meaning no one other than the two parties in this case were given access to this document. That furthers the speculation that the leak is coming from someone within the umbrella of Team Trevizo. What also happens to be interesting is that one side has reached out to this witness to figure out these leaks, and that has been the district attorney who apparently reached out to the quote-unquote media company, aka this defense witness, about having the judge's sealed decision. Because like I said, that document was only available to the two parties in this case. So it begs the question, how the defense was made aware of this TikToker who had these medical records in the first place. I'm extremely curious because, as we've seen, Gary Mitchell does not appear to be extremely tech savvy. I doubt he found the medical record leak on his own, but that is simply speculation I cannot prove but ponder as to how he was alerted as to these medical records being posted by, at the time, a completely unknown person on TikTok. I looked into this leak based on my suspicion that the medical records in question were state's evidence, which would be extremely interesting and extremely legally relevant to this case for a few reasons. Number one, should the hospital have actually messed up and released these medical records somehow to this TikToker, which was, in my opinion, being heavily implied online as to who the source was for these records, but also seems to be false, that would really help Alexee in both her criminal and civil cases should the hospital have negligently given these medical records to a random TikToker, which seems patently false at this point. So, due to all of these weird things, I felt it would be smart to keep tabs on the situation. Number two, the other interesting legal reason, and I'm only proposing this reason, I'm not accusing anyone of doing this, simply stating that it could be a strategic move due to the high likelihood that the medical records were always going to remain as evidence in this case based on New Mexico state law. New Mexico state law requires the state to get a court order for the medical records. Even though we do not have access to the proof of the existence of this court order, technically, the fact that the judge did not suppress them highly implies, if not guarantees, that there was always indeed a court order for the medical records, like we had speculated on this channel. Was there a possible attempt by anyone to impact the admissibility of these properly obtained medical records? We cannot imply that, but we can only wonder if that is the motive behind anyone in this chain of the league. I hope all that makes sense. If you're still confused or have any questions about the leak portion of this video, leave them down below and I will clarify and respond to you because we will move on here. As you see here, I've written treatment versus statement. So this is where we'll be parsing out the medical information in which the judge has ruled is admissible or inadmissible. Essentially, all statements have been deemed privileged, whether in the presence of law enforcement or not. So all statements made by Alexee have been deemed inadmissible up until this point. All medical treatment records have been deemed admissible. This leaves us with some issues, understandably, why a lot of people are confused. So here are the three issues I see. Number one, how will the treatment be testified to? Witnesses will be limited in explaining the circumstances surrounding the treatment listed in these medical records. So it'll be just the treatment with no explanation or anything including what the patient said. Number two, the medical records include statements made by the patient and her mother in the notes made by the nurses/doctors. So would those have to be heavily redacted? The rest of the notes would be in and it would make them extremely clunky. There is still a downside for the defense with this being that it will be hard for the jury to not understand how Alexee got where she got with or without her statements. You'll have to make the medical staff look completely incompetent rather than being tricked. And even then, the medical staff were not with the defendant in the locked bathroom. They did not know of the born child's existence. So with that, how incompetent can they be deemed by this jury? And now number 3, the inconsistency in the fact that a court order was likely issued based on the probable cause for these medical records, but statements regarding that care made by the patient are not considered part of that care, which is extremely interesting. This can feel a bit confusing and opposing, which is why I'm breaking down treatment versus statement. It feels inconsistent because should this have happened in any other facet of our society other than a hospital, there would be no privilege afforded to the defendant or the witnesses involved in this situation. So that is why this is an extremely interesting decision that the Supreme Court will be making. There is an exception to the privilege referenced in case law very similar to Alexee's from New Mexico, in which they talk about furtherance of crime or fraud not being afforded to attorney-client privilege, meaning you cannot use or speak with your attorney in furtherance of crime or fraud. Will the Supreme Court decide the statements made to the hospital staff were in furtherance of a crime? They might sense the surrounding evidence seems to show that the defendant did not attempt to alert anyone of the truth of the matter, allegedly of having a child in the bathroom, that a jury should be allowed to decide the intent of those statements made to the hospital staff and disregard this privilege? Or will they parse it out until before and after the crime was allegedly committed? All of this will play into these medical records being either fully entered or entered with redactions when the nurse or doctor refers to statements made by the defendant. Okay, from here, we're going to look at a few quick clips from the motion hearing that happened last August, almost to the day, and see some things that are mentioned regarding the medical records as evidence and some of the judge's thoughts before having made this decision. Almost a year before, months and months before she makes this decision, the judge does speak on some things. So let's go through these clips.
And the hospital's obligation is until they have a proper waiver of that privilege, they can't talk about it. And here's
and then she has to make a knowing waiver after being advised what her right is in event to waive it.
Well,
right?
There's no case law on what a knowing waiver is. That's always been, did she sign a waiver? Okay. We've always done that on a case-by-case basis. I'm not going to tell you that I have a particular case, although I haven't done this in civil cases and in other cases, classically, there's a written waiver that is signed that you can waive that. And that's not done in this case.
So let's just try and pick apart what he said here. According to the state, Alexee did sign a waiver. Now, number 2, there has to be intent for the doctor to try and incriminate Alexee when involving the police in the conversation. The subpart of that, it would appear that while doing a pelvic exam on the patient, the doctor was pulled out of the room, informed of someone who I believe is Lori, calls the police, but the doctor calls Loveless Hospital to get the patient transferred. So as much as the defense, at least in my opinion, is going to try and make it seem as though the doctor just ran and called the cops and ignored Alexee, it doesn't appear that that is what happened in the time in between the baby being found and the doctors being walked into the room. Now, the doctor states when speaking to the patient, I just got off the phone with Loveless. It's quite possible that the doctor just didn't wait and ambush Alexee. Okay, it's kind of being phrased like that by the defense, in my opinion, but I don't think that that was the intention of the doctor. The doctor also seems to have the first thing on her mind being getting Alexee, the patient, to agree to be transferred for life-saving measures as well. So we could go to the next clip.
Huge problem is mass media, social media. How it got out is, I guess, an issue that the district attorney and I will have to look to sooner or later. But the truth is, it got out. All these records, all these videos were out. Now, somebody from Artesia had to disclose that. Every one of them gave a statement to police. They shouldn't have without a waiver. They all gave records they shouldn't have without a waiver. They gave a video they shouldn't have without a waiver. And classically, when you read the case law, there are 3 ways. Number 1, you get a waiver from the patient. Number 2, a court orders it. There is no court orders in this case. They didn't go down and say, Judge, we need a search warrant. We need an order from you ordering the hospital to turn over the stuff to us. They never did that. They just did it. And then, in fact, there's a videotape in this case where the officer goes in and asks the administrator of the hospital, what do I need to do? He says, well, just send me an email. That doesn't cut it. It doesn't cut it under HIPAA. It doesn't cut it under this rule. So my point is that the privilege applies.
Again, we're back on the waiver thing. So we have number one, the waiver, number two, the court order. Now we have this attorney down here on another clip that I'm going to bring up right now.
Records, the hospital records, the police department was given the records, but they did apply for a search warrant and obtain records properly by court order. And so a claim of privilege that we didn't get them by court order for a crime, the state believes that that is the exception.
As you see, she states that there was indeed a court order for the medical records in this case. Number two, by order of the court, this is the exception to the privilege of the medical information in this case. So if his arguments, the defense's arguments, are a waiver and a court order against a lot of this information, well, it appears that we have both. To the next clip.
I can, and you need to address it in two ways. Number one, what is the presence of the mother due to the medical doctor-patient privilege? That's number one. Number two, what does it do under Miranda suppression rules? Well, the latter first. Under Miranda, it doesn't matter who's present. They have to read her when she's in custody and she couldn't leave. The officers were there. They say it in their reports. And then they don't read her Miranda. The doctor asks a question. And you can't do that. I've cited some cases and wrote on that in the response or the reply to the response.
Now, number one, privilege can possibly be waived by the waiver and the court order if the Supreme Court decides as much. The issue of Miranda, if the defense loses the privilege being applied to the statements made in the treatment room in front of the doctor, their only hope is Miranda to apply to Alexee's statements, which brings up our next issue.
Talk to me about, and here's what I have on my mind, about the state alleges that Ms. Trevizo waived any privilege by allowing her mother in the room when she was in this, you say it was custodial investigation or interrogation. Does anybody speak? She was advised she was not free to go.
Is this an interrogation or an investigation? Number one, for an interrogation, you must be detained. You don't have to be under arrest or in cuffs or anything, but once told you're not free to go, statements can now most likely need Miranda warnings should they want to be used. Investigations are allowed to start at any time after probable cause has been determined by the officer. Probable cause was met in this case in order to start the investigation. The question becomes, how far were the police/detectives allowed to dig into this investigation from the outset prior to any court orders? But the judge herself hits on, is this an interrogation or an investigation? She literally said that herself, and then she must have deemed it an interrogation.
It is apparent to me there may be some distinct acts or events that occurred that are privileged or may be privileged. I'm seeing other. I can't lump this into one event, a long-running event. I think we've got, for example, I'm thinking that the whatever happened in the hallway, which I think is just a video of her going from, I guess, a treatment area down the hallway into the bathroom, right? That's a public area. I can't see that video would in itself be a privileged video. I've got other questions about other parts. I do think it's a good idea that you submit findings of fact in this case.
So, as you heard the judge state, she cannot run this into a long-running event, which is what she ultimately apparently did when she suppressed any and all statements made by the defendant and only gave the medical records as an admissible piece of evidence, likely due to state law requiring her to have to allow those medical records to be admitted as evidence due to the exception to Rule 11504. That's just my opinion, but I don't see why the judge wouldn't have excluded these medical records if she could have, since she excluded everything else. We'll move on to our last two clips here, which are just interesting moments that defense attorney Gary Mitchell speaks on and asks about the medical.
And I knew that, and I expected to just use it as a proffer of what the records show. Ms. Luce didn't say anything about Exhibit A, which are the medical records that came from Artesia. I copied those straight from what the state gave to me. So I don't know if the state has an objection to those. You're going to have to look at them some point in time to decide. Well, Judge, because
Okay.
the argument is going to be, anyway.
Okay.
I do need to know if the state objects to Exhibit A, which were their medical records.
I wanted to bring this up one time here at the end because the person who leaked these medical records online was put on the defense's witness list. The state had already preserved their right to call any witnesses disclosed by the defense, which is what you see number 24 here. That is the 24th line on the state's witness list. Any witness disclosed by the defense. Now, should it have been implied to the court that it was the court's fault or the state's fault or anyone else's fault that these medical records got out? Now, if it did happen to be someone from the umbrella of Team Trevizo, as admitted to in this message from the defense witness, it would be extremely interesting what either side would decide to do. So we can truly question, what was the motive behind leaking these medical records? Was there any legal motive to have a story behind this evidence that would be more favorable to the defendant in this case? I am not accusing, simply speculating as to why these medical records found themselves online. It appears that only the case has reached out to this witness via thinking that they were a media company who had this information, though the defense is the one who wants everything sealed, but they have not issued a cease and desist or attempted to do anything to stop this person from sharing information in the Alexee Trevizo case, despite making them a witness due to the leak. My apologies for not being able to share the contents of the medical records, but like I said, I respect sealing orders of a court, and I do believe that the more legally significant issue surrounding these medical records at this point is the leak and the fact that they are now admissible. Should the message I obtained that was sent out shortly after these medical records were leaked by the leaker to an extremely large TikToker be correct, the one admitting that it was Alexee's sister giving her these records, the state has indeed preserved the right to call any witness that is disclosed by the defense. And now the leaker has been disclosed by the defense to the state. It's anyone's game as to who wants to get to the bottom of the truth of the leak and possibly use it in court. Thank you so much if you made it this far in this video. If you have any comments, questions, or concerns, please leave them down below and I'll get back to you as soon as possible. And I do genuinely enjoy the conversation. If you're interested in following cases like the Alexee Trevizo case to trial, please subscribe as I'll be covering it all along the way with a legal focus. It's your girl Friday. I'll see you in the next video. Okay, bye.